number 116, the people of the state of New York versus Leroy Savage Smith. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court. Phil Rothschild from the Hiscock Legal Aid Society on behalf of Mr. Smith. First, I'd like to reserve 2 minutes for rebuttal.
You may, sir.
Okay. The Fourth Department erred in finding that Mr. Smith did not proffer specific allegations of a seemingly serious nature to...
Is there a reasonable view of this record that the defendant was only asking to represent himself and not for substitution of
I do not
counsel?
believe so, and I don't believe that the Fourth Department found that either, in as much as that they didn't find that. And the court itself found that Mr. Smith was, in fact, asking for new counsel, and stated this twice in the record. Mr. Smith said, so I'm not getting a new attorney. So I would submit that that argument has no merit. A minimal inquiry was required here, and we would submit that the Fourth Department's determination was contrary to the facts, the law, and public policy. Mr. Smith was charged with assault, and he raised a self-defense claim saying that the complainant pulled a knife on him. There were 15 to 25 people in the area, probably 25, and the area was under constant surveillance. Prior to jury selection, he asked for new counsel and alleged essentially ineffective assistance of counsel, in that his attorney never tried to contact any of the exculpatory witnesses, never conducted any investigation, and most importantly, told him there's no money to hire an investigator to talk to these witnesses in North Carolina. The trial court, without any inquiry, just told him he was too late, but he did allow him to represent himself.
So he had appeared in court on 8 other occasions, is that right?
Yes, Your Honor.
When he was asking for counsel to be discharged, the jury was just about to come in, as I understood the record. Is that
That is
right?
correct, Your Honor.
So it seems that he's arguing that he has a justification defense. And so wouldn't the court be entitled to look at the whole record and everything that the court's heard so far, Mr. Rothschild, in making this determination as to whether or not you should make any inquiry? In other words, could the court look at the whole record, or does he just have to look at what the defendant says in front of him at that time? And if he looks at the whole record, do we have to say it was unreasonable for the court to say that, you know, you don't have a justification defense here, you're going nowhere on this, this is a waste of time, and it's just a stalling tactic?
Your Honor, in this case...
It seems that that's... And it seems that we have to measure, was the court exercising discretion to do that? Tell me why that's wrong, Mr.
Your Honor, I think the facts in this case don't support that, in as much as of the 25 people there who were in line waiting to be paid, the police spoke to 7 of them, meaning that there's up to 18 possible witnesses who could corroborate Mr. Smith's account.
This is the case where the man's accused of hitting somebody with a hammer over the head, right?
Yes.
And did 6 of those people testify against him?
6 of those people testified against him.
They all said he hit him.
Yes, they all said he hit him.
And there's an email follow-up where he says, see what happens when you don't give me my money.
Yeah.
I think the proof is tough, but to follow on with what Judge Fahey is saying, I think is, so I think the strongest point in the transcript is he told me I didn't have funds, access to funds to hire an investigator. If the judge had said to the attorney at that point, do you believe you don't have money? And the attorney said, no, that's not what I said. Would that be enough?
I think that would be a good start. And I think if he said yes, I think the next question would be, why did you tell him this?
Yeah,
Are
but
you
soon
not
he
aware
says,
of
no,
722?
I never said that. That's crazy. Of course, I know I can apply for funds anyway.
That's a different situation than what we have here. But, I mean, remember...
Well, you have to walk a fine line, don't you, in terms of you don't want to display the defense tactics necessarily in front of the people and whoever else may be there. But it seems to me that, you know, at least, was that your belief, counsel? As you say, might be a good start.
And I would
right?
say inquiry was warranted because in this case, as I said, there was 18 witnesses, and there's no indication in the record that there were any defense witnesses that defense counsel contacted any of them or any request for investigative services.
But again, I think then you start, as Judge Stein, I think Judge Fay saying, you start to get into tactics and proof and defenses here and the overall kind of what are you doing? Because the question may be, you didn't contact these other 18 witnesses. He says, no, because I told me you hit him over the head with a hammer, and they're all going to say the same thing. He told me you didn't have a knife. I mean, I've had cases where we had hearings. Why didn't you get a handwriting expert? You call the defense lawyers because he told me he wrote the book. You don't want that coming out in the middle of the courtroom.
True, you don't want that coming out, but also you need to investigate when there are seemingly serious requests, and I would submit that Porto is fully distinguishable from this case.
So then the inquiry into whether you thought you were under the impression you didn't have funds wouldn't be enough? Because then you would have to get into tactics.
I don't think you necessarily have to get into tactics, because I think in this case it was fairly clear that defense counsel, given the history in Onondaga County, given the history of this case, there was nothing to show that defense counsel had conducted any type of investigation whatsoever. The failure to investigate is ineffective assistance of counsel.
Right,
Now,
and isn't that more in line with a 440, though, because there are many reasons why you wouldn't investigate, including he told me you wrote the book. So in a limited inquiry on this type of a coming in right before the jury is at least the panel, I think, is coming into the courtroom, would it be enough for the judge to have said, are you under the impression that you don't have funds?
I think as I said before, I think it's a good start. I don't think it's necessarily enough, because I think more would be required, especially when the allegations of failure to investigate and the allegation of the ignorance of failure to investigate is ineffective. I mean, this court has said so time and time again. The way you can show, as a defense attorney, you can show that it's not, is to show that you used your professional judgment.
Would you have a sealed hearing then?
Yes, I think that's a possibility.
And make the sealed hearing record going into tactics available for appeal?
That would be a possibility, but I think it's also incumbent upon the court to conduct an inquiry, but also to make a record.
But is your point that the court should have inquired whether or not counsel had made a decision about the investigation as opposed to asking what did you do to investigate?
I think to start with, he should have asked the question, did you tell him this? Because I think that is, according to the Supreme Court in Hinton versus Alabama, ignorance of the resources available to defense counsel is the very hallmark of ineffective assistance.
What about the simple question to counsel? Counsel, are you available, are you aware of the availability of funds for investigative purposes?
That would have been a good start. But I submit that the public policy, unfortunately, and I see that my time is low, the public policy in Onondaga County is to historically, according to the Spangenberg report, as noted in Judge Kaye's commission, to routinely discourage assigned counsel from hiring investigators, and that was borne out by statistical analysis of 14,000 cases showing that investigators were hired not in 30%, not in 13%, or even 3%, but 0.3%. That is a shockingly low number. Now, the Harrell hearing is hopefully will improve that, but I think it's still incumbent upon the court to do their part, because they must be solicitous of the rights of the accused.
Is that a little bit different, sort of knowledge of the law and being discouraged from acting on that knowledge?
Well, I think that in this case, given that history, the court should have definitely taken more attention of that, because it's not entirely unreasonable to believe that an attorney would believe that there are no resources or funds available.
Judge, it would be all right if I just ask one
Yes,
more
of
question?
course.
Mr. Rothschild, is there a difference in his request between saying, I don't want this attorney, and in other words, I want to represent myself, because it doesn't seem like there's an explicit request for a different attorney. I was just looking at the record again as I was sitting here, and I didn't see that explicit language that.
I think the danger is this, insofar as that he needed someone to do the investigation. Under Barker versus Wingo, he's in jail. He can't do it himself. For him to represent himself is no substitute to do the things which needed to be done. He was waiting in jail.
So
in
you're saying
vain.
that the request for to have more investigation done, that he didn't investigate properly, is equivalent to a request for a different attorney?
I think the nature of, because he cannot do these things, he can't conduct the investigation.
But you would agree with me that the record doesn't show that he actually asked for a new attorney?
I think it was understood by the court to mean that. It was understood by the Fourth Department to mean that, and I would submit that. Thank you.
Thank you.
Thank you, sir. Mr. Maxwell?
Good afternoon.
Mr. Maxwell, what would the harm have been for the judge to have asked the simple question before they went out? Counsel, are you aware of the availability of funds designated for this specific purpose?
The danger, in addition to the things that have already come up about exposing defense tactics, is
Well,
that you risk driving a wedge between the defendant and the attorney. Well, now he's calling me a liar, Judge. Well, I can't go to trial with this lawyer.
Don't you
People
already
just-
have the wedge, based on what he's already said in the open court?
Well, to his credit, the defense attorney didn't stand up and say, Judge, he's lying about me, and
Yes,
this
I
is
understand that,
outrageous."
but certainly, despite whether or not he's specifically asking for substitution of counsel, it's very clear he's dissatisfied with his attorney, so you already have that on the record. I mean, I think what the chief judge is asking, if the judge's inquiry is just about counsel's knowledge of the law, that doesn't reveal any tactics, at least I
And-
can't see what tactics that might reveal, but that might at least, whether it's a good start or not, at least resolve this question about the attorney, defendants saying something that suggests that the lawyer is uninformed or ignorant of the law.
And under your theory, the judge could never ask any question at the risk of driving a wedge. But that's the whole purpose of the inquiry, is to find out whether there's a problem.
What I'm suggesting is that the judge has a discretionary call to make at every step of the way, and he did not abuse his discretion as a matter of law in handling it the way he did. And I contrast it with the case that's cited in an amicus brief filed in this case by the New York Civil Liberties Union, People versus Bryan, where the court diverted the discussion to whether he wanted to go pro se. Now, the defense would like to view the discussion that's in the record for about 16 pages from A262 to 278 as two separate things. And there is about 2 pages where they don't talk about this. But I ask you to look at it as a whole. He starts off with the word, I want my lawyer relieved, not replaced. He later goes into, I'm at a disadvantage with the attorney. And from what we know of his summation, we know exactly where he was going.
But the court says, I'm not at this stage going to assign another lawyer. I mean, doesn't that
Right.
indicate that that's what the court understood he was asking for?
Well, he was trying to understand what the defendant was saying, and he says, if that's what you're asking for, and the defendant doesn't say yes or no, he says, I just want to make a record. And then when it comes up again, the judge says, my understanding of what you're asking for is to represent yourself. And again, the defendant doesn't dispute that. He says, I want to ask the questions. He got what he asked for.
But isn't that, with, at least to this extent, with the defendant's knowledge that the judge has already said, I'm not going to assign you a lawyer?
I don't read it that way.
Well, and defendant says, in other words, you're not going to grant me a new attorney. I'm going to be my own attorney? So,
Well, again, he's making a statement. He's recapping where they are in this discussion. Nowhere in the discussion
but why
does...
would he say you're not going to grant me a new attorney if he wasn't asking for a new attorney?
He didn't ask for a new attorney. That's nowhere in
Use
there.
those words, but what would be the point of saying that if he didn't understand and the court didn't understand that that's what they were talking about?
He was voicing where they were in this discussion. And he was recapping it, and that's what they, and he didn't say, and Judge, I think I need a new lawyer. I want a new lawyer. And again, I want to just point to the summation. The end of the summation, he says, you know, I've never been in much trouble at all with the law, or something like that. He killed a guy in North Carolina. The attorney, before trial, got a very favorable Sandoval ruling to keep that out. Our trial prosecutor is figuratively beside herself because now he's been allowed to tell the jury he's a good guy, never been in trouble, and the judge won't let her put in that he killed a guy. He
So what
would
are you saying
never
then?
have had, I'm sorry, I don't want to do.
Okay, I know, I'm asking what the point of that is.
The point is, he would never have had that opportunity to lie to the jury.
So you think that was a strategy from the get-go? He knew,
Yes.
he knew so much about this that he was planning on doing
Yes.
that?
He knew he couldn't testify throughout the trial, the way he questioned the witnesses. Well, wasn't there a Volkswagen over there, and wasn't
But let's
the
assume
plumber
all
over
of that
there?
is strategy that occurs now after this colloquy, and there is no assignment of counsel. Aren't we still left with the question, what was the judge's duty and obligation based on our case law when the defendant indicates dissatisfaction and that it appears that counsel is ignorant of the law?
And under your case law, the judge has to only make the inquiry when there's a seemingly significant the phrase is escaping me, but seemingly is in there.
Seemingly
And
serious.
Seemingly serious request.
So isn't ignorance of the law about whether or not he can have funds to do a proper investigation seemingly serious? What more would one need to say? What more would a defendant have to say?
I think from the judge's standpoint is that's just doesn't make any sense. Our lawyers know that that's not the law. This lawyer knows that's not the law. It's a lawyer he's had in front of him, a lawyer who got an acquittal in a trial in front of him shortly before that. That as a matter of his discretion, he does not.
Should the judge have said that on the record?
He
I
could have.
find that statement to be unbelievable and incredible.
What he did say on the record, he could have said that, but what he did say on the record is, based on what you're hearing, what I'm hearing, it's a general thing. And again, he says he didn't get exculpatory witnesses. He doesn't say there are exculpatory witnesses. He doesn't say I gave him the names of so-and-so, the phone numbers, the addresses. He just says he didn't call exculpatory witnesses without saying there are any. The judge viewed that as a general statement. And then the discussion went the way it did to the defendant saying, all I want to do is ask the questions. That's all I want to do. He got what he wanted to do. So again, going back to, I mean, it would make it easier for you. It would make it easier for the appellate division if the judges pounced on these and interrogated everybody. But it would also grind their trial system to a halt.
I'm not really clear why it's an interrogation, just to ask, not about tactics. Do you know the law? The chief judge's formulation of that question.
Right. That is a very...
3 seconds? I mean, I
3
don't-
seconds leads to, well, Judge, that's what he told me. Well, no, that's not what I told you. And
Okay, well,
around
there
and
you're
around
done
it
now.
goes. I'm not saying he,
I mean, we don't have an appeal.
I'm not saying that it would have been okay
So,
for him
Mr.
to handle
Maxwell,
that
what
way.
is the threshold to trigger the inquiry that's necessary for a judge to make under these circumstances? What would it be?
Well, it's what your case law says it is. The judge has to, in his discretion or her discretion, find the seemingly serious matter here, seemingly grave enough issue that he has to make that, or he or she has to make that inquiry.
So then I get back to the question. So is it your argument that in a case that involves multiple witnesses, a serious, very serious assault case, where the defendant is claiming that his lawyer told him there's no money to investigate whether or not any of those witnesses would come forward on your behalf and support your story, that's not seemingly serious allegation, that failure to
Again, looking at sitting in the judge's seat with jurors on the first floor walking up to the third floor to his courtroom,
I get it.
6 witnesses brought up from North Carolina, trial scheduled for months.
But we're not asking him to make the determination that he should grant the request. The only issue that we are addressing here is whether he should have made that minimal inquiry, whether it was enough to make a minimal inquiry. There may have been all sorts of reasons or answers that the judge would have received that said, I'm denying this. But that's not the question before us.
Well, again, what I read what the judge was saying was, from what I've heard, it's general. And you haven't given me specifics,
Again, that's what we're looking at.
Right.
Was it specific enough
Right.
to warrant that inquiry?
So you're not taking the position, which I thought maybe was the position you were taking, you have to step away, that we can infer that the judge made a determination that it was incredible, that the statement or statements the defendant was making about the failings of his lawyer was incredible, based on, as you're saying, this history with respect to this case and this defendant and this lawyer.
I don't know if he was finding it incredible. I think he was looking at the entire situation and finding the entire situation incredible.
So then, shouldn't that be on the record? So then,
Well, what was on the record was him saying that I think this is too general, and then if it had gone the way...
and if that's the case, can't we then infer that he wasn't making a determination that it's incredible?
Well, I think he was looking at it as, you haven't identified that any investigation would have gone anywhere, and it then progressed to where it went, to all I want to do is ask the questions. I want to represent myself. The judge didn't force that on him. He made those decisions. He has to live with that decision. So I'd ask you to affirm.
Thank you, sir. Mr. Rothschild?
The court does have discretion in determining whether there's good cause for substitution, but that discretion must be informed. The three factors, the timing of the request, the status of the case, and whether counsel is competent or not, there have to be questions, even if the judge suspects that it's merely for the purpose of delay.
That's what we're looking at, right, as they're saying. So if we say that what rose to the level of requiring an inquiry was the statement, he told me he didn't have resources, and the question I think has been formulated here, are you aware that you have access to resources? Seems a very straightforward back and forth without getting into tactics, very clean, minimal. Any time a defendant raises that, if we rule that way, and these scripts do get around, so any time a defendant raises that point, and a judge, it could be the jury, I think it was the panel that's coming in, not the actual jury in this case, right? But let's say the jury's walking into the room. We've had 5 days of jury selection. We've had months and months of pretrial motions. Defendant stands up, says, this guy told me I couldn't get I didn't have access to funds. Judge says, no way, sit down, we're going to trial, reversible error.
Yes, absolutely, because the exercise of discretion requires information. Otherwise, it's merely...
So you're saying it's not a minimal inquiry, you must make an inquiry, is what you're saying?
It's a minimum, the inquiry is like, do you know County Law 722?
Sure. No, I get it, but
there
you're
are
still
never-
saying there must be an inquiry.
I believe there must be an inquiry, especially when a case of prima facie ineffective assistance of counsel is alleged. The court can address it very simply. This is a de minimis burden upon the trial court. And secondly, regarding the Ferretta inquiry that was done in this case, that has been held not to be a substitute for a sides inquiry because they're totally different issues.
So you're not arguing that if defendant just got up and said, he doesn't know the law, my counsel doesn't know the law, that you wouldn't say that's not enough.
That's not
Not
specific.
enough. It's that this specific assertion by defendant about his trial counsel's ignorance, which has already been found to be ineffective assistance of counsel, is enough to at least get you the inquiry.
I believe so, Your Honor. And as far as whether, the court may have believed this, I think that the reality in Onondaga County, as shown by the Spangenberg report, shows...
So if we agree with you that require, if a judge just doesn't believe it, that they must say on the record, I don't believe you.
I think the court has the obligation, yes, to make a record.
And if the judge says, I don't believe you, is that enough? Is there some other claim now that nevertheless the judge should have made some inquiry, even if the judge, given all of the circumstances, just doesn't believe this statement?
Well, I'd like to say yes, but I think the facts in this case are even stronger insofar as what we have in front of us, 17 witnesses who were never contacted, the history of this failure to hire investigators in Onondaga County. I think this is something that should have been at a minimally inquired about by the trial court. And I would ask this court to reverse and remand for a new trial.
Thank you, counsel.
Thank you.